Good morning, friends. Sat Sri Akal, Adab, Namaskar. This is again the similar case, Manalal Agarwal. This was an appeal filed by the Union of India in the High Court Jurisdiction of Bombay. First appeal number 49 at 1985, which we discussed from the lower court to the session. We are reaching here. Now, being aggrieved by the judgment of the civil judge, civil suit 1563, decided in 1983, the appellant above moved the following: that the judgment court below and whatever, that the findings of the learned are based on assumptions, that the learned trial court has failed to appreciate that the evidence adduced by the appellant is trustworthy and reliable, that the court below erred in law in not properly appreciating the rulings cited. The court below has equally erred in not interpreting the various rules, legal provisions, and admissions of the property situated within the limits of the cantonment. The court below has obviously erred in the law in not appreciating and in not properly interpreting the principle of laws regarding to the rights and prescriptions, and therefore the findings given, that the court below has erred in not placing the burden of proof regarding the proving of ownership title of the suit land on Ajaib Singh, Vithobai Singh, Ratan Singh and Kalabai. Now see what the department is playing. It wants the plaintiff to prove all this in the Evidence Act. So this is where I keep saying we do not need to be plaintiffs. We always have to come in the secondary part. The court below has not framed proper issues in the suit, exceptionally when it is admitted fact that respondent number 1 that all lands of these 4 villages were originally belonging to Maharaja of Bikaner. It was for the respondent number 1 to prove how and what basis the ownership of the land survey number vested with the predecessor in Kalabai. Matlab, they are even finding an issue between the king and his pattedar. The court below ought to have appreciated absolutely there is no iota of evidence regarding title of respondent 1. Appellant have emphatically denied the sale deed executed by Kalabai in favor of the respondent number 1 on the ground that Kalabai had no rights to title whatsoever the suit land, and therefore she was not entitled to sell the suit land. This is where the whole department works on. The court has failed to appreciate the original sale deed is not on record and no permission ought have been granted to lead secondary event, exceptionally when the appellant have denied the execution of the sale deed itself, in spite of the fact the learned trial court has erred in holding the execution of the sale deed is proved on the grounds that the appellant admitted the same emphatically, exceptionally when the appellant was the execution of the sale deed. Court below was cultivating the suit land on the basis of rent. They don't have a sale deed, they don't have a lease deed, they don't have a rent agreed, but yet they want this. Respondent number 1, while claiming that Ajaib Singh was holding patta regarding the suit land from the rural of Bikaner, has not been proved. The court below ought to have appreciated the appellant have satisfactorily and with positive evidence proved that facts of Kalabai and her predecessors were cultivating the land on rent and produced ample evidence to show documentary evidence. The general land register showing the ownership of the suit land of Union of India has not been accepted by the documentary evidence. The court below ought to have appreciated, proved that the suit land was cultivated by her predecessor only on the basis of annual rent based, but learned trial court accepted and appreciated the documentary evidences produced by the appellant and has wrongly come to the conclusion that Kalabai and her predecessors were owners of the suit land. So the department wishfully is going against everything, is not ready to admit, wants its GLR, doesn't want any sale deeds to be there. The court below have taken into consideration was miserably failed to establish his title over the suit land, and therefore it ought to have been appreciated that respondent number 1 is not entitled to a degree of possession. You are in possession, but you are not entitled. Quote number 1, fact the respondent claimed 7 acres of 24 guntas only, where land survey number. In much more, no explanation whatever was given in claiming 7 acres, and the learned judge has not given proper findings on that change from 17 acres to 7. Survey number or revenue receipt number 20 was acquired by the Union of India for cantonment gardens, and depositions were given by respondent number 1, which has again not been appreciated. They want their witnesses also, what they are saying is to be said, they are final because they are government servants. So there are so many things which this court actually wanted, and so these were the basic grounds of the appeal which was filed in the High Court. First appeal number 49, and finally this case came up in front of the judge on 12th July 1993, and the order was pronounced, how things moved in this case. So basically Suraj Kundwala, but the whole details do not need to be read. I will just go to the conclusive part. It goes down to say, however, in the appeal, the matter was remanded to the trial court. The revision petition against this order was preferred to the Hyderabad High Court by the original defendant number 2 and 3, who are now the appellant number 2 and 3 in this appeal, wherein the lacuna of section 439 corresponding to section 80 was directed to be corrected. An objection was raised. The suit was not maintainable. In consequence, the suit was withdrawn as per the order of the Munsif in 1955. It further contended in 1952 that a partition had been effected in the family. So these things kept going on. So the defendant number 1 filed written statement as Exhibit 66, stoutly contended that Hiralal could never got title in suit land under the sale of 1941. Hiralal was never put in possession of this land. However, regarding proceedings under section 447 of the criminal procedure, conceded that such proceedings did not take place, and such proceedings ended in withdrawal and the acquittal of the plaintiff regarding the suit for partition, and so on. 1902, the government of India acquired 4 villages. Now here the amount is being said 37,000. And what was the amount said in the lower court when the 1963 judgment was being worked out was a different value. Over there the department had given the figure, what I would read into is somewhere 27,047. So look at the variations coming up. But we have to work on a very different. So General Sikandabad, the officer commanding Aurangabad, they pick up a telegram of 9 revenue survey number and so on. These kind of documents are being brought in. Payment of an annual rent of 13 annas, 8 paisa and 9 guineas or whatever you could do, cantonment board, by the lady called Kalababi. What I am trying to read through this entire case, the department was heckled. It was not willing to accept this fact that there is so much of evidence in this where the GLR mismatching is happening. There is no record brought in of acquisition. The DC of the Aurangabad should have been brought on record for evidence. He should have produced all the acquisition papers. The revenue receipts which were to be verified were verified by Manalal. So there were so many things which were happening. Now Manalal, as Exhibit 212 has stated, that his land survey number was popularly known as Suraj Kundwala. It was ad measuring 17 acres 24 guntas, and the land revenue that was payable was 35 rupees. He has also stated that some land were acquired by the government for cantonment gardens. He has been in possession of 8 acres from the southern side since the date of the purchase, 1951, when he was dispossessed by cantonment. Tracing the history and so on, everything was brought on record once again. revenue receipts have been exhibited in the High Court. So Manalal has stated a lot many things, testified his sale deeds regarding the private claims. Okay. The other witness, Krishnamurthy Harashetty, is also serving in cantonment. He is unable to say as to whether the property belonging to the government of India is required to publish in the government gazette. His proposition that all lands belong to cantonment within the boundary pillars, GLR plan. He also admits that the transfer of properties in the cantonment area are registered in the office of Sub-Registrar Aurangabad. Of course, the cantonment board maintains the register of transfer of lands. Now, these are two admissions coming way back in those years. That TP Act was applicable. The record was maintained because after 1924, the sub-registrar powers were taken away from the cantonment magistrate and they went to the DC. Till then, it was all with the cantonment magistrate from 1864 to 1924. So, these amount of under section 3(1) notifications, learned resistant despite facts, kept referring. The sale deed executed by Kalabai is recital there shows the land belonged to Kalabai in succession from her husband Ratan Singh. So, these extracts are all there. So, what do we prove? The High Court was, whether the GLR or whether the document, we were moving from Exhibit 244, 246, 247, the Journal Land Register, where B4 class of land, Rule 8(4) shows that B4 or B3 class of land are the lands which are not included in other classes and which are suitable for disposable or building sites. They are the lands not required for military purpose. Even if for a moment we hold that survey number 7475 are a portion of survey number 20, it would be clear that these lands were not useful for any military activity. And section 108 of the Cantonment Act refers to so and so. Sub clause F refers to land by gift, purchase, etc. So we again, the High Court is saying, where is the record? Where are the documents? Nowhere. So we are only fighting on the subsequent rules which the cantonments made. If the land is situated in cantonment area, the same shall belong to cantonment. The whole case is falling on this part. Now, in the counter, we have judgments of P.T. Ankleshia. It cannot be laid. Then we firmly have these judgments. Evidence Act, Section 35 and 114 very clearly says that these entries form maintained are not to be presumed as correct. All these things, and reading through the merits of the case, finally the High Court said that for all reasons we feel that this appeal as devoid of merits, and accordingly we proceed to dismiss the same with cost. The judgment degree passed by the trial court is hereby held. So friends, we need to all wake up. What is happening? This finally appeal goes to the Supreme Court, where Manalal CA number 4581 of 1995. The judgment has been brought in of 1980 of Pune cantonments. So all this has been happening there. But here there is a very important thing which happens in this case. It has not happened in the history of cantonment. An application is moved by the Union of India to lead additional evidence under order 1127. What do the court says now? What is the new addition? What is the Solicitor General trying to say? He is simply saying that there was a notification of 1951, 8th July 1950, to be taken on records as an additional evidence under order 10, 20, 30, 41 Rule 27 of the CPC be allowed. And just imagine, this is an order in 2001. The Supreme Court remands back a winning case just to lead an additional evidence. And when it comes to bungalow owners like the Chitra Kumari or SS Das versus, the courts do not allow these applications because they fix to the findings of the admission or the ownership. And this is, it's no point in getting into the nitty-gritty. So the mindset, I'm not saying anything against the courts, but the truth is this. And this case is remanded back, and finally Manalal Agarwal expires. This application is allowed and the case comes back to the lower court again, senior division, where a case was filed and which was decided again in 2005. In my next video, I'll be reading about that. Thank you. Good day.